Welcome everyone to this webinar with Clemens Kaupa, Assistant Professor of Vrije Universiteit. I don't know if I pronounced that correctly, but in Amsterdam at least. And you have written several articles on the area of fossil ad bans and the legal issues and aspects of those. And we're very, very happy and pleased that you're here and looking forward to hear your talk. And yeah, very, very warmly welcome.
Okay, great. Thanks so much. Thanks for having me. Some of you present here I already met in the last couple of months, so that's very nice to see. I'll share my presentation now. Is it visible? Excellent.
Yes.
So fossil advertising ban, some considerations from perspective of European law. This is in some ways like a little an overview of either topics that I've been researching in the past couple of years or legal topics that came up in discussions in the last couple of months. Hopefully it'll give you some form of coherent overview. The issues that I would like to cover is first the existing rules on misleading advertising, and could it actually be argued that fossil advertising is already illegal, and fossil advertising I use now in this broader sense of both advertising by the fossil industry itself, but also for other high carbon products like aviation. The second point is then legality of national and local fossil ad bans under European law. And this topic came up really in response to a discussion we had in the Dutch Parliament at a seminar in January. And it was just a question that a legislator had, like some kind of uncertainty. Is there, if we pursue this objective, will there be pushback? Will there be problems from a European perspective? So less, let's say, a specific challenge that was experienced, but more like a kind of uncertainty. And I wrote this study on this since January, which essentially seeks to show that ultimately there is no major problem from a European law perspective, but I'll focus on this a little later. And the third pan, maybe issue a little bit specific, maybe does European procurement law pose a problem for a local fossil advertising ban? This essentially came also from a discussion that we had with a Swedish local council, where the local councillors got, let's say, responses from the city government or municipality, which said maybe there's problems from a procurement perspective, from a competition law perspective, and we just worked it out why probably there's no major problem from a European law perspective. So this might just be illustrative for what types of pushbacks you could hear about and whether you have to take it overly seriously or not. Starting the existing rules, on the European level, the relevant instrument is the Unfair Commercial Practices Directive, and this is then implemented into national laws. So in the Netherlands, in Germany, in Austria, there's in the national laws, you find these prohibitions back. So the national implementations of this directive would then be applied by courts or by consumer authorities. And the core prohibition of the Unfair Commercial Practices Directive is the prohibition of unfair commercial practices. And what are unfair commercial practices? These are commercial practices which are contrary to the requirements of professional diligence. We'll discuss about this in a bit. And the practice must materially distort or is likely to distort the behavior of the consumer, which means nothing more than the advertising or the commercial practice needs to have the potential to influence the consumer in some way. So that's the general prohibition. And then there's two specific types of prohibition. On the one hand, misleading commercial practices which are relevant for us, for advertising, and aggressive commercial practices which are not relevant for us. So zooming in on the misleading commercial practices, Article 6 and 7 of the directive, commercial practice is misleading, and that includes an advertising, if it either contains false or otherwise deceptive information, or it omits information that the average consumer needs to make an informed decision. You see, it's very broadly formulated, really like a very broad prohibition. That's the first criterion. And the second criterion is this commercial practice, this advertising must be liable to influence consumer choice. Not a very like a significant criterion. This prohibition also applies to any kind of environmental claim, which is the way how fossil advertising came more into the focus of this regulation. There is not that many examples, but there are of fossil companies which are targeted by lawsuits under like misleading commercial practices. This one would be one example from a couple of years ago by the Italian Consumer and Market Authority against Eni, where you see in this advertising, Eni is promoting green diesel, which with like this environmental imaginary attention for the environment, it says, and this was found to be greenwashing, so misleading advertising. And that was like a significant fine, actually, I think 5 million euros, if I remember correctly. Another example, more recently from Germany. In Germany, the Deutsche Umwelthilfe has launched a broad range of lawsuits against all kinds of companies that make CO2 compensation claims. So we are a CO2 neutral company. And one of the advertisings that was successfully targeted by a fossil company was Total Energy, which sold CO2 compensated fuel oil. And that was found to be misleading by the court. So existing rules are already available to target fossil advertising. The problem, of course, is that this is case by case, right? So you'd have to target one case, then it takes a long while and costs money and legal risk, and the next one, and the company will just switch its strategy a little bit and then just continue the same communication. However, I think it is arguable that already the existing legal framework, if interpreted a certain way, can already be said to ban fossil advertising in a more general sense. And the way it could be argued is to say, we look back now at our Article 5, which, as I said, bans commercial practices which are unfair or contrary to the requirements of professional diligence, a really open term. And this term is defined as meaning a standard of special skill or care that the trader may be reasonably be expected to exercise towards the consumers. And this lawsuits based on this kind of general duty of care of a company towards the public or consumers. This has already been used successfully in lawsuits, especially in the Netherlands, Urgenda lawsuit against the Dutch government, and Milieudefensie versus Shell against Shell, which also were based on a very broad duty of care. And the way we would, in our interpretation of the directive now move forward, would be to say, well, we have this general requirement of professional diligence that the advertiser is subject to, but we can fill in the meaning through various legal and scientific sources. So first of all, we know that according to European law, emissions need to be cut radically. That's in the EU climate law. We also know that companies are subject to human rights obligations, so they actually are bound to act in a way that does not violate human rights. And climate related. So the corporate actions may also violate human rights by like in the climate context. Yeah? And the third thing we know is that from a climate science perspective, we know that consumption changes will have like a strong potential of reducing emissions. So in this way, it could be argued that existing rules already today prohibit fossil advertising because it promotes unsustainable consumption patterns and thereby violate requirements of professional diligence. Now, this is, of course, legal argumentation, and that's certainly not the, let's say, the majority interpretation currently, but this is something that can be brought forward and that can be forwarded in, for example, cases or in publications, etc. So the way to relate the existing law to a fossil advertising ban, to a legislative fossil advertising ban, would be to say a new law that creates a fossil ad ban does not change the existing law, but in fact, it only clarifies it, right? So if properly understood, the current law already prohibits fossil advertising because it just promotes unsustainable consumption patterns which violate our legal obligation. And introducing a legislative fossil advertising ban either on national level or local level or on European level is just making this more concrete. And in fact, I would say in practical terms, any kind of lawsuits or complaints against fossil advertising under existing rules are in any ways complementary for the push of a legislative ban because it communicates how fossil advertising is just so systematically deceptive. Okay, that was my first point. My second point that I was asked to discuss was legality of a national or local fossil ad ban under European law. So in other words, if you pursue a national or local ad ban, are there any problems to be expected from a European law perspective? Spoiler alert, I don't think that's the case. I would like to discuss briefly about existing advertising restrictions, then about the competence of member states to enact a fossil ad ban, and then possible legal challenges against a fossil ad ban. First, advertising restrictions, there are many under EU law. Apart from the ban on misleading advertising that we already discussed, there is a ban on alcohol advertising or restrictions on alcohol advertising, a ban on promoting prescription medicine, and of course the ban on tobacco advertising. And there's also numerous national examples from tobacco and alcohol advertising restrictions in areas not covered by EU law to restrictions on gambling and betting advertising. So the takeaway here is that advertising restrictions are not something wild and radical. In fact, it's a really common regulatory tool to curb harmful impact of products and communication practices. Zooming in now on the best known and maybe most important example of an advertising regulation, tobacco. Historically, we see that the first restrictions on tobacco advertising, they start in the 1960s already, with some countries having comprehensive bans already in the 1970s. And on the EU level, regulation only starts decades later. So 1989, the first one, and then the Tobacco Advertising Directive and Tobacco Products Directive, which contains rules on electronic cigarettes. So the takeaway here is that national regulation can really precede European rules. Countries, local level, they don't have to wait for the European Union to act on this. In fact, it works the other way around. It's often necessary first for member states to act before the European Union can then start to create rules to harmonize the rules between the member states. So one could think about national regulation as a form of laboratory for new types of regulation. From a content perspective, the tobacco ad regulation, as you of course know, contains a comprehensive ban on all commercial communications which directly or indirectly promote tobacco products, and ban on sponsorship. And this approach has been challenged in the past decades by numerous lawsuits, but the legality of it was by and large confirmed by courts. So that's an important takeaway, I think, in the discussion about the fossil ad ban, is that there is not necessarily a need to start small, right? To say we just ban certain types of advertising. There is a historical example of a comprehensive advertising ban. And it does make sense to, let's say, mirror or like to match a fossil advertising ban also on that example. For tobacco advertising to be a good example for fossil advertising, the question arises whether there's parallels between the two products, and I think quite obviously there are. In fact, the parallels between smoking epidemic and fossil fuel epidemic have been increasingly highlighted over the past couple of years, and particularly also by the public health community, which speaks of fossil fuel dependence or addiction to fossil fuels in analogy to the to tobacco and other substance abuse epidemics. Two parallels to point out. On the one hand, the promoted products do cause comparable harm. Climate crisis is, among other crises, also a public health crisis and has health effects that are comparable or worse to the smoking epidemic. And in both epidemics, advertising plays an important role. So in the case of the smoking epidemic, it's well documented that advertising played a central role in making, but also in maintaining this, this epidemic. And it's also well documented that the fossil industry is following the tobacco industry's playbook. So the takeaway here would essentially be to say, because we have two phenomena, smoking epidemic, fossil epidemic, which are in many ways comparable, it's also legitimate to take the same regulatory approach to them. So comprehensive advertising ban as one part of the strategy to contain the harm of these products. And on the other hand, because they are so parallel, we also can expect that the legal challenges that tobacco advertising was subject to can tell us a lot about what kind of legal challenges a fossil advertising ban will likely encounter, and whether these challenges will be likely successful or not. Briefly about the legislative competence, not a big issue. Member states do have the legislative competence to enact a fossil advertising ban. Fossil advertising ban relates to a broad scope of goals, protection of environment, consumers, and health. And in all of these areas, member states either share the competence with the EU or hold it exclusively, which, as a rule of thumb, you can say that as long as the EU has not comprehensively harmonized fossil advertising, which it hasn't, member states are competent to regulate. And just to add here, on the European level, EU law prescribes a high level of protection of health, environment, and consumers. So this also creates some kind of, may create some kind of certainty that even like a relatively strong advertising ban will presumably find support in these objectives. And already moving to the last part of this bit, what type of possible legal challenges against the national fossil advertising ban could be imagined under European law? So three main types of lawsuits could be imagined. First, under the freedom of commercial speech. So European law, just as national constitutions, grant freedom of speech, which is typically extended, not in all countries, but in most countries, to companies. Then the right to conduct a business. And finally, the free movement of goods and services. So this is like an EU right, like you have the right to offer goods and services in another country and not be discriminated or hindered in this. And a national fossil advertising ban will presumably restrict all of these rights in some form. It will make it will limit commercial speech. It will make the right to conduct a business a bit more difficult. However, these rights are always justifiable if there are overriding grounds of public interest. And this means they need to pursue a legitimate aim, and it needs to be designed proportionally. And obviously, a fossil advertising ban would pursue a legitimate aim, protection of health, environment, consumers. And proportional design means essentially that it doesn't have to go further than what's necessary, and that all the relevant interests are duly taken into account in the legislative process. To illustrate, I would like to look at 3 example cases from tobacco, and I think they are somewhat illustrative of also like for a fossil ad ban. So the first case is Philip Morris brands from 2016. This was about the Tobacco Products Directive, which holds far-reaching restrictions on the labeling of cigarette packets. So what companies can put on the cigarette packets. For example, they cannot promote any kind of flavorings or any other types of like benefits or health benefits or so on their packages. And that was challenged by the company as a violation of the freedom of speech. But the Court of Justice of the European Union said that these labeling restrictions do not violate the freedom of commercial speech. In fact, the freedom of the undertaking to disseminate information in pursuit of its commercial interests is outweighed by the objective of ensuring a high level of protection of health. And this is essentially how all kinds of like rights cases under EU law work, is that you get to this balancing, right? And here the court said protection of health is just more important. Takeaway here is that a legislator, rulemaker on the national or the local level has to strike a fair balance between the regulatory objective, so protecting health, protecting environment, and the various rights that are affected. For example, the rights of this company. What it does not mean is that you have to go a middle way. That's not what it means, the fair balance. In fact, what it means is that in the legislative process, during the rulemaking, you need to take account of all the interests. You need to show, for example, like through studies or in the discussions, in the legislative materials, that you have paid attention to the different interests that are involved. But if at the end, the legislator says, for the protection of health, we also like radically cut the freedom of commercial speech of a tobacco company, then that's also fine if you can justify it well. Second example case, Pillbox. This also concerns the Tobacco Products Directive, which, as I mentioned, also holds an advertising ban on electronic cigarettes. So essentially, far-reaching ban on any type of promotion of electronic cigarettes. And that was challenged by a company as a violation of the right to conduct a business. And here the court also said that this advertising ban does not violate the right to conduct a business. The advertising ban is proportionate, so it does not go beyond what's necessary in the light of the goal of protecting public health. And maybe one interesting takeaway here is that the court said that the ban does not affect the essence of the right to conduct a business, as it does not prevent economic operators from manufacturing and selling electronic cigarettes. So here, what the court points towards is that there is an important difference between a sales ban and an advertising ban, right? And an advertising ban is actually a less restrictive means than a sales ban. Sometimes it's argued, people say, well, if you ban advertising, then you would also have to ban sales. And if you don't do that, then this would be incoherent, but that's not true. So you can actually argue, well, for now, we continue to allow like selling these products, but we still want to, for health reasons, for environmental reasons, ban the promotion of these products. So that's a legitimate approach. Last case, Philip Morris, Norway. This one concerns a law that bans the visible display of tobacco products in stores. This was challenged as a violation of the right to free movement of goods, so the right of a company to sell goods in another country. And the court said, likely or in all likelihood, this does not violate this right. So also here you have the balance. On the one hand, the freedom to sell your products in another country, but on the other hand, the right of the state to regulate for the protection of health. And here the court said protection of health just more important. What's an important takeaway here is that the court said that even if the legislator is not completely certain from a scientific perspective that this advertising ban will achieve the goal of reducing the consumption of tobacco in this case, it doesn't mean that the legislator is not allowed to act. So the legislator can also already take an action even if the scientific evidence is not perfect yet. So what's sufficient is that the legislator was reasonable to assume that the measure would be able to contribute to the protection of human health. And if you take this analogously to, for example, a fossil advertising ban, then you would say presumably, even though it's in some ways probably difficult to develop a clear scientific evidence that fossil advertising is causing more consumption of fossil fuels or so, then you can still make as a legislator a reasonable assumption that probably there is this type of connection. Summing up this part, the case law on tobacco advertising shows that even a far-reaching advertising ban can conform to European law if it is justified on grounds of public interest, which is the case in the tobacco example and presumably is also the case in the fossil fuel example. So my take is that because there are these strong parallels between fossil and tobacco advertising, there's good reasons to assume that the same logic will also apply to a fossil ban, especially if a fossil advertising ban is modeled after tobacco advertising ban. Okay, so let's say summing up this part, I don't believe that European law poses these major problems for a fossil advertising ban. With the number of takeaways that I mentioned. Last point, this is just a brief issue. One of the points we discussed in the last couple of months, as I mentioned, is that from lawmakers from Lund municipality, they were told by the city government that the fossil advertising ban could violate some European laws, and they mentioned EU procurement law and competition law. And I was forwarded this email, and I was just like, wow, really? It didn't strike me as particularly reasonable. Then I looked into it a little bit, and there is some plausibility in the argument, but it's not. I don't think it's very convincing. So just describe you a little, and then tell you my takeaway from this. So what is what are we dealing with? Local governments, they have often advertising on their property. So for example, advertising on bus stops. And one way of how a commune municipality can restrict fossil advertising is by preventing these advertisings to be shown on their property, right? And these advertising spaces are typically managed by a private company, for example, JCDecaux, and they have a contract. So there's a contract between the municipality and the advertising, this advertising operator. So we're not dealing with a kind of a vertical relationship where the government orders something, but it's in some ways a relationship between a private contract, right? And in order to create this fossil advertising ban, the municipality would have to include this in its contract. So this would be a concession agreement. So it would say, you run these advertising spaces for me, but you're not allowed to show, for example, advertising for air travel. And how could EU procurement law become relevant here? Well, EU procurement law regulates how public authorities can make these contracts with private parties. And the essential objective of procurement law is that city governments or state governments, that they don't discriminate against private operators, that they don't use these contracts to create some benefits for like their own national companies and discriminate against companies from Sweden, Germany, or Austria, or whatever. So the goal here is that public authorities, they need to conduct the award procedure, so the rules of how they contract, in an objective, non-discriminatory, and transparent manner. But what procurement law does not prescribe is the content of these agreements. So there's the principle of free administration, which essentially holds that public authorities should be free to decide how the provision of services should be conducted. So summing up, my conclusion from this discussion was that EU procurement law does not create a major obstacle to local fossil ad bans implemented via a service concession contract. And maybe this is just illustrative of something that could happen to you, that you hear back from public authorities, no, there's like potential challenges under this EU law and that EU law. And I would just take this with a grain of salt and say, presumably, given your experience with the tobacco advertising ban, you can, take a good guess that a well-regulated fossil advertising ban will also not conflict with any EU rules. That would be my take. So that's also my summary. EU law does not appear to pose particularly problems for national and local fossil advertising bans. And what I think would be a good next step is to start working more on bringing together and also creating the scientific evidence that supports a fossil ad ban, because that, of course, is necessary. That new regulation, especially if it is restrictive to the interests of corporations, must be based on good evidence, right? We need to make a good case for this prohibition. Okay, that's all from my side. Thanks so much.
Thank you so much, Clemens. It's really lots of really crucial information for